am Margot Kaminski. I'm a professor at Colorado Law School, and I have the honor of moderating our final panel, The Costs of Privacy, Surveillance of the Poor. I wanted to begin by thanking all of our previous participants, including but certainly not limited to my esteemed colleagues, Professor Skinner-Thompson and Professor Chen. I found this morning to be absolutely wonderful and really reorienting for me in terms of how I think about privacy law. So this panel, the final panel, is going to be focusing on the impacts of both privacy law and policies and the lack thereof on people in positions of extreme poverty or even ordinary poverty. And the description of the panel runs roughly as follows. U.S. privacy law, for those of you who spend any time with the Fourth Amendment, or really any time with any privacy torts at all, is notoriously home-centric. Right? It privileges the home as one's castle, and it privileges those who are affluent enough to buy a home or to build higher walls. So homeless shelters, for example, are often privacy-starved environments, and public assistance programs, as we heard from Dr. Bridges in the first panel, have long intruded into people's lives, forcing them to trade personal information for what are often modest material benefits. So this panel will discuss how privacy and poverty intersect, addressing how socioeconomic status intersects with privacy violations by both state and non-state actors. So I have the privilege of welcoming three panelists today. In no particular order, in fact, in alphabetical order, we have Tristia Bauman, who is a senior attorney at the National Homelessness Law Center. We have Karen Levy, an assistant professor at the Department of Information Science at Cornell University, who is also an associate member of the faculty at Cornell Law School, and Dalia Ritvo, the assistant attorney general at the Colorado Attorney General's Office. So welcome to all of you, and thank you for taking the time to join me today. As with our other panels, the way we're going to structure this conversation is by directing a question to one of you initially, and you can take up to 5 to 8 minutes to respond to that if you'd like, or shorter if you prefer. And then after that, the other two panelists are welcome to add on their thoughts, either in response or in addition to what that panelist said. So we'll begin with a question directed to Tristia. So Tristia, as I mentioned in my introduction, privacy law is notoriously focused on the home as really the paradigmatic example of a private location or a sphere in which privacy is accepted and protected. So in what ways are public assistance programs, shelters, and homelessness policies privacy starved, and how does this impact people's lives on the ground?
Thank you both for the opportunity to talk about that and for that good question. First, what I would point out is that when we talk about home-centric, we probably should think of it as housing-centric because people living outside do consider their outdoor homes to be homes. Having said that, they are not extended the practical access to privacy or legal privacy protections for a number of reasons. And I think, a little bit of context is important here. Essentially, and I summarize it as privacy is a luxury that unhoused people can't afford. And there are a number of reasons for that. One, the practical. People live outside in public space when they lack access to traditional housing. So they are in the public view. There is no way to escape public eyes. The alternatives are usually congregate shelter settings, and these are temporary settings, usually offering only a single night of accommodation, and they are congregate, meaning that you do not have a private room in most instances. You are going to be on a cot or a bed next to a large number of other people, so there's no practical privacy in that setting. At the same time that people don't have any ability to shield themselves behind a door, close, their windows, there are a growing number of laws in this country that cause unhoused people to be subject to heightened police surveillance. So since 2006, the Law Center has tracked 187 cities across the country and looked at laws that target the life-sustaining activities of unhoused people when performed in public space. And these are entirely innocuous behaviors that everyone listening to my voice right now is engaged in. Things like sitting down, standing still, falling asleep, normal human behaviors that are treated as offenses, either criminal or civil offenses, when a person is performing those acts in public space. As a result of the increased policies that target those actions, people are subject to increased police surveillance and police contact, as well as, so that means, direct police contact and police surveillance. They will be monitored by patrols, but also the use of technology, often by police departments, to again monitor the location of where people are and the activities that are occurring in and around their outdoor homes. A couple of examples that come to mind are the use of drones by the city of San Diego, for example, to monitor people who are living in vehicles that fly over parking lots where people living in vehicles might park, or a new plan by the city of Miami to install surveillance cameras to monitor areas where people are camped outside, not only to watch their activities, but to catch, and this is, an official plan, to catch people who are engaged in unlawful food sharing. So, this surveillance can capture even people who are good Samaritans trying to provide needed services to people living outside. In addition to that police contact, there are other tools that are used often by law enforcement or what I call vigilante groups, enabled or emboldened by these policies that make living outside unlawful. Online groups, Nextdoor, Facebook groups that are dedicated exclusively to monitoring unhoused people's whereabouts. They will post pictures of people online, identifying information, and law enforcement often participates in these types of online platforms. There's an example in West Fernando Valley in California where law enforcement were active participants identifying unhoused people and giving information about their criminal histories or mental health histories online to perfect strangers. We know that there are other encampment maps that track where individual people are. So there's, a great deal of that type of surveillance. There aren't a lot of legal protections available, though, so that, it's not clearly established, and most courts have found that the privacy rights that are extended to all of us who live inside of traditional homes do not extend to outdoor homes, particularly when those outdoor homes are unlawfully in public space. So what that means as a practical matter is that your outdoor home can be searched or seized without the ability to resort to Fourth Amendment privacy arguments in court. I mean, it's just a lawful activity to search the outdoor home. It doesn't get much better when you go into the shelter system or into housing programs. And the reason for that, there are varied reasons for that, but I want to just focus on two things quickly. One, of course, is the lack of privacy inherent in some of those models. There just isn't enough individualized space. But also when you enter in, for some good reasons, data is collected from the individual so that you can be part of the homeless management information system, for example. So they'll take your name and private information, ask you questions about yourself. That goes into a database that is then accessible to a large number of people, and that's a cost of entry. And so there is private information that has to be given up in addition to just a basic lack of privacy that we would all recognize. And that can also be true in housing programs. So even when somebody is in traditional housing, there are a couple of dynamics that I think make sense to flag here. One, people who are in those programs can be subject to different tests and required to provide information about themselves, their household, that are not required from other people who live in housing and may benefit from a housing subsidy. For example, somebody who has a housing voucher, is participating in a housing program, may have routine inspections of the inside of their home. They may have to take drug tests. They may have to provide information about their job searches. That type of invasion into private life, private decisions, and private space does not exist for those of us who seek a mortgage interest tax deduction, which is also a housing subsidy. And so, there's a real distinction in how people are treated, even when we're talking about the same category of things, housing subsidies. And the last dynamic that I'll end with is because people who are experiencing homelessness are, by definition, our least resourced neighbors. They're often members of marginalized groups. When they do access housing, when they find a landlord who will accept a voucher, when they are able to get into a program, there can be a lot of abuse related to privacy invasions because they don't have the type of leverage to fight back against, for example, a landlord or property manager just opening the door and walking in to see what's happening inside. As a practical matter, even if that may be a violation of the policy, the alternative to accepting it is to risk losing that housing. And so, there are a lot of abuses that take place in that vein as well that I think are important to highlight here.
Thank you so much. Karen or Dalia, did you have additional thoughts on this? I did have a few follow-up questions, or really observations that are somewhat questions. So first, in keeping with some of the themes I've heard over the course of today, it really sounds like one of the core moves this conference is making, and that your observation makes as well, is to force us to expand our notion of what a privacy law is, or really what a privacy violating law is. Scholars often focus on things with the word privacy in the title, or on sort of historically traditional privacy regulations such as wiretap laws or eavesdropping laws, when it turns out that having a law that creates a very expansive definition of an underlying offense is in fact a privacy violating, or at least privacy violation propagating instrument, right? By making certain groups subject to increased policing, increased enforcement, increased surveillance. And what I wonder is, given that, could you zoom in a little bit for us on what laws in particular you would characterize as privacy implicating, that a traditional privacy scholar might not characterize in that way?
Sure. Well, an example would be camping bans. So camping bans are present in about 3/4 of the cities in our country. And many of those are camping bans that cover all of available public space. So there's literally no lawful place where someone who lacks indoor housing can stably live outside. Again, I'll note that the alternatives for people who don't have housing often is just outside, because the shelters provide really temporary accommodation, not only temporary in terms of you can't be there for multiple weeks or months at a time, but you can be there usually for a limited number of hours in each day. But the need to shelter oneself and or to rest exists beyond, just those limited hours. Camping bans are written really broadly to include a wide variety of activities. So it can include the things that we all think about with camping, erecting a tent or some sort of temporary structure. It could also include putting down a piece of cardboard and sitting on it while awake. It can include resting on a bench with your backpack. It can include just falling asleep outside with nothing but your clothes. All of those things can be considered unlawful camping. Because it's unlawful, people who are performing those activities, and those are unavoidable survival activities, they are violating the law and can be, and often are, approached by law enforcement. And not only does that act expose them to a lack of privacy, they'll often lose their property as a result of that interaction, or even when there's not an enforcement activity, meaning no arrest, no ticket, no order to move along, they still may be subject to a really common practice, and I know this is very familiar to folks in Colorado, sweeps of homeless encampments, where again, the outdoor homes and property that people own are usually just seized, sometimes destroyed wholesale, sometimes temporarily stored, but they're still unlawful after that temporary storage period expires. As a practical matter, people often don't get their property back, even when it is stored. And that means that the structure that people use for themselves is lost, along with the privacy implications that come along with the displacement and enforcement. And that same, at the risk of making this answer too long, I'll say that laws restricting living in vehicles do much the same thing. That's the fastest growing population of unsheltered homeless people, people who move into vehicles. And we're anticipating a large wave of people moving into their vehicles as the pandemic puts so many renters at risk. Laws restricting living in vehicles are the fastest growing category of laws criminalizing homelessness. People's vehicles can be impounded with very little notice, sometimes literally just a knock on the door. You've got 15 minutes to grab what you can before the tow truck comes. And the fees for retrieving your vehicle are often totally unaffordable to unhoused people who are using those homes as shelter. And that same exposure takes place after a tow and impound of a vehicle home as well.
Thank you so much. I promise we will turn to the other panelists shortly, but I had two follow-up questions. So one was that, Professor Skinner-Thompson and I have each been interested in how one might use the First Amendment to basically provide privacy protections where privacy laws otherwise might fail. And I was curious, just as a doctrinal matter, whether there's been any success in using First Amendment doctrine to push back against some of these laws. The second question is thinking of Dr. Allen's wonderful keynote. I wonder what we think could be learned from these stories by re-centralizing an otherwise marginalized community in our discussion of privacy, what privacy is, right? What privacy harms are. So two things I hear running through the examples is that this really challenges two basic privacy paradigms in our law, one of which is that if you're in public, you have no privacy. And the other is that if you share information with others, it must be voluntary, must be consent, and therefore you have no privacy. So two related concepts.
That's right. Well, starting with the second question first, it's critical that we rethink what homelessness is in this country. There is a misguided and incorrect belief that unhoused people are outside because of poor choices that they've individually made or because they are choosing to live outside in public space. And that is incorrect. There are a number of housing and criminal justice policies, as well as federal disinvestment in local communities that have led to the modern homelessness crisis. Those are policies that are inherently racist, which has led to a disproportionate number of unhoused people being people of color in this country. And we don't have adequate supports for other vulnerable populations. That's why we see 40% of the unhoused population being people with disabilities. So rethinking what a home is when we have a scenario where there literally is not enough housing for people who need it, and people who are attempting to recreate adequate housing for themselves outside in the spaces that are actually accessible to them is key to any sort of development in privacy law, and also just key to understanding how we should think about civil and human rights in this country. Regarding there aren't a lot of legal arguments that protect one who is living outside. In the context of First Amendment arguments, camping can be expressive conduct under the First Amendment, but sleeping in an encampment is not necessarily expressive conduct. There's a case that talks about having a kind of symbolic tent in order to express concern about homelessness, but there is no correlating right to occupy that tent and be free from punishment. So really, what I'd like to see, and where there has been some success, is expanding upon Fourth Amendment jurisprudence. What is society prepared to recognize as objectively reasonable in terms of expectations of privacy in outdoor homes, especially when people lack any other place to live. And if you're alive, you have no choice but to live. I think that's where there's, you know, the most fruit. We have seen some success under state constitutions, you know, the Fourth Amendment analogy in state constitutions. There's, you know, a great case out of Washington State, Pippin, that I think could inspire a similar litigation around the country. But we're still a very long way from protecting the basic civil and human rights of people living outside.
Thank you so much. That was a great kickoff to this panel. So turning now to you know, platforms and people, or between employers and employees, and in particular impact low-income persons and low-income communities.
Thanks, Margot. I'm really excited to be able to join the proceedings today, and I've just learned so much, even just on this panel. Tristia, I'm really affected by the description that you gave and just how incredibly stark the situation is for folks who are unhoused or who have to use public assistance programs, and how overbearing those privacy invasions can be. It's quite reminiscent for me of Kiara Bridges' point this morning about being without privacy rights, like no matter what you, right, if you do or if you don't, right, if you seek assistance or if you don't. So thank you very much for sharing all that with us. To your question, Margot, about kind of exacerbation of power asymmetries in different domains. Yeah, you know, I think of surveillance as really fundamentally being observation plus control. And so it's pretty inextricable in my mind to think about these dynamics without thinking about power, without thinking about power asymmetry, because surveillance is just how power manifests a lot of the time, right? And I think we see that in the context that Tristia is talking about, and in lots of the prior panels as well. So it's not surprising, right, that the relatively less powerful party in a relationship, in an institutional relationship or personal relationship or an employer-employee relationship, is often surveilled by that more powerful party as a means of sort of keeping them in their place, you know, retaining the power structure that exists. And you see this pattern play out over and over and over again across domains and across scales, certainly with respect to wealth and income, but also to other dimensions of inequality. So, you know, certainly on the community level, we know that historically communities of color and poor communities and marginalized groups and social movements have been subjected to really stunning degrees of state surveillance. And Scott has done the privacy community just an incredible service by centering these narratives in his work, as have so many other folks that have presented today, including, I'm not even going to name them because there are so many, like really truly everyone today. And in my mind, this is the most important privacy work, is the work that centers these narratives. To ensure, right, that the privacy policy conversation kind of retains its focus on this reality, rather than sort of abstracting away the subject of data collection, which it sometimes has a tendency to do. So this also plays out on the individual level, and my own research focuses a little bit more on those dynamics. So I'll just give you two quick examples from my own work. So I spend a lot of my time thinking about surveillance and privacy dynamics in like everyday institutions that people sometimes think of as being non-legal, although they're deeply shaped by the law. Like families and workplaces. So with respect to low-income workers, as you asked, Margot, in some of my work, I argue that kind of the fundamental way we should think about data collection technologies in the workplace is as a reallocator of risk and burden and cost from the firm to the worker, right? So we often like to talk about how in the workplace, you know, data collection and automation and AI and other technologies like remove inefficiency, right? Like help us find and cut waste. And that makes a lot of sense from a managerial perspective. But from a worker perspective, like a lot of times what we actually see happening is not the removal of inefficiency, just the movement of inefficiency to workers who are, of course, less powerful and less able to bear that, right? So from a worker's perspective, you know, now workers bear, for example, the risk of fluctuating customer demand because they have algorithmically determined schedules, and in the interest of, you know, better predicting customer demand, workers are subjected to these just-in-time scheduling practices that make their lives really unlivable and prevent them from working second jobs and have negative impacts on their kids. Right now, workers bear the cost of what sometimes gets called shadow work. Craig Lambert has this really good book called Shadow Work, like work that's considered kind of residual and thus not compensable, right? Like, you know, an Uber driver is paid for the time that it takes them to drive the passenger from point A to point B, and not the time that they then are leaving point B and like finding another passenger or cleaning their car or getting gas, right? Like all of these kind of residual activities. And we see that's not a new dynamic, like that's existed in work before, but new technologies enable like increasing granularity when it comes to what we consider sort of essential compensable work tasks. Workers are now the ones that are punished for what managers like to call time theft, which is just like not working yourself to the bone. Essentially, right, if you don't work at a pace that's kind of revenue maximizing, then that's considered time theft, right? And of course, we know quite a lot about different technologies that allow managers to have a much more granular and real-time view of what it is that their workers are doing. So the point here, right, is that none of these inefficiencies just like vanished, right? They all still existed. They all still exist. They just get hidden because it's the less powerful party that's bearing them, right? Because the collection of data about them is enabling that dynamic. And then, at the risk of going on too long, I'll say this more quickly. The same kind of power dynamic plays out in families. So, in some of another line of my work, I think a lot about privacy and intimate relationships, ranging from, what we might think of as kind of relatively anodyne or even beneficial digitally mediated care of children or of elderly parents, all the way to the like very clearly objectionable and problematic end of the spectrum, like tech mediated IPV, intimate partner violence and surveillance. And something that comes up in like across all of these different intimate relations, of course, right, is how power shapes those dynamics, some of which has to do with money, right, some of which has to do with other dimensions of power. So, like the person who is considered the head of household is the person that buys the Nest Cam, right? And that's the person that Google treats as the user. That's the person that gets to set the rules for its use. That's the person who decides how it's going to affect less powerful folks in the household. In the elder care setting, the adult child often serves as the legal representative for an elderly adult who may have dementia or other cognitive impairments in a lot of cases. So the adult child acts as both kind of a surveiller and the person who's consenting on the surveilled party's behalf to like who's consenting to that data collection. And then in the context of tech-mediated abuse, financial dependence we know is like a key limiting factor in reducing tech-mediated surveillance, right? Like whoever signs the household up for a cell phone family plan has access to everyone's communications data, right? This plays out in like lots of really mundane ways, actually. So the point, I think, of all of these different scenarios is that power is really inextricable, and data collection is just a tool of power in all of these circumstances. And that we can see this, again, playing out in these very small scale relations, including like my relationship with my kid or my spouse or my relationship with my boss, in the very same way that we see it playing out across communities, right? And between the government and residents. And the common denominator is just that the powerful, again, use data to sort of retain their position and to entrench power differential. I feel like I just like got on a soapbox and like threw that all out.
No, that's great. So again, my brain always goes to the like, what can I be using here, right? And I heard two things in particular that I wanted to get you to elaborate on more. So the first was this call to not abstract so much, not just in considering the harms, which I think we've talked about a lot today, but actually in outlining the data subject. And data privacy laws are nothing if not incredibly abstract about who the data subject is, right? Mm-hmm. Down to the reasonable expectation of privacy, which, as I've talked about with my wonderful seminar students recently, is actually kind of a reasonable man test, right? It's a reasonable white cisgendered middle class man test, or really a who's the judge on the bench test. So in what ways the examples you've just given concretize the data subject, or really data subjects in some cases, in ways that should influence how we think about these scenarios legally?
It's a great question. I mean, I think you're of course absolutely right that we have this tendency in constitutional and in statutory regimes to sort of flatten the subject to, as you point out, oftentimes the white cisgender man. Even if we're not so specific, the assumption is largely kind of embedded in the tests that we use and the rationales that we use. I mean, to me, it comes down to something that actually Francesco Ochillo said this morning, which I thought was really apt, which is just about thinking about options, right? Like who has what options, right? So the law, I think, doesn't hardly ever, right? Like privacy law thinks about what other options folks have, right? Like that's most stark in the context of notice and consent, right? Where we say like, well, we'll just assume that your consent is meaningful because you had other options and you probably entered into this willfully and, that it has some meaning. And like, of course, we know that that's a fiction, but I think it's just as much of a fiction across all these other contexts, right? Like that's no way to accord meaningful protection to privacy. So I think for me, thinking about realistic options and recognizing just sort of the entanglement of privacy decision-making with these other institutions, right? With the fact that I have to have a job, right? Or I have to live in a family, or I have to, sleep somewhere, as Tristia points out. Like, we sort of pretend all of those other entanglements don't exist, right? When we think about privacy, and that's really dangerous, I think.
Yeah, so my second question to you, I'm actually going to save until after we talk to Dalia, but to hint at it, I think some of this is based on the fact that the central, other than the Fourth Amendment, the central regulatory paradigm in the U.S. is privacy as consumer protection, which sort of pushes us into these artificial understandings of consent and choice, because that's the way that paradigm is really framed. So I'll come back to you with that as a question. But in the meantime, let's turn to Dalia to talk about how predatory practices that are based on big data influence the experiences of low-income persons and communities. So one thing that I was thinking of was the practice of payday loan targeting and other predatory lending practices that are really based primarily on the surveillance of the poor.
Yes, thank you, Margot, and thank you for including me on this wonderful panel. I should give you my standard disclaimer that the views I espouse on this panel are my own and not those of Attorney General Weiser or the Office of the Colorado Attorney General. So just putting that out there, as most government workers do. So this is an area, anytime that we go online, most of us are somewhat knowledgeable of a social contract that we're making with the vendors that we're using, whether it be social media websites or other marketers that are selling us goods and services. And we've kind of made a social contract to relinquish a certain level of privacy so that we can be directed to whatever we want. It seems pretty innocuous when you look for a pair of shoes and then you suddenly see a bunch of ads that are selling you those very shoes from numerous places. But when you are a marginalized or underserved population, it becomes much more targeted and much more problematic. You also might be limited in the options that are served to you. So in the space of predatory lending, for instance, if I, as your standard middle-class person, I'm just going to use that as a baseline, would be potentially, if I'm looking for financial services, I might get offered credit cards, might be directed to traditional banks, traditional loans, et cetera. If I'm flagged as someone of lower income, lower education, potentially race, not always race, but potentially race, et cetera, then I might only be shown what are considered more predatory products that are out there, for instance, payday loans, et cetera. For those of you who don't know, payday loans generally have, I think the APR on a standard payday loan can be around like 800% of what you originally borrowed. If you look at the statistics, I've seen everything from most people who obtain a payday loan go through 5 to 10 cycles of re-upping the loan for one loan before being able to pay it off. So this means that individuals are not able to pay at their next paycheck, and they never were able to pay at their next paycheck because they're covering basic needs, electricity, water, food, rent, what have you. And so their paychecks aren't fully covering these types of costs. They're not seeking more traditional loans. And actually, if you look at just the financial credit, it's probably better to get a credit card to cover some of these costs. But the people believe they either are not allowed to access that type of credit or loans, that they don't have access to banks. They're usually underserved with respect to those products. Generally, they may not have bank accounts, et cetera. And these lenders also have direct access to individuals' checking accounts or their paychecks themselves, meaning that they have direct access to the employers, which creates all kinds of havoc and problems. In addition, some of you may have seen the case that the FTC recently settled against, I'm forgetting the name right now, sorry, Lead Express Inc., amongst other defendants. It was referenced as the Harvest Moon case. This is a highly problematic payday lender that used all kinds of unfair and deceptive practices to lure people in. And then what they were doing was just collecting fees every month from people's accounts rather than collecting on the principal. And they were automatically re-upping the loans without some proactive action on the person who took out the loan. Hugely problematic. And then if you see the marketing materials that they use, they buried this practice deep into the small print of the contract that was not downloadable or available to the person to keep and read later. They would continue for up to a year or more until somebody canceled their checking account or changed their accounts. All of this is, I mean, to a traditional person, any person generally would be hugely problematic. Add to that the people who generally seek out these loans are usually very strapped for cash. It's highly problematic. The Consumer Finance Protection Bureau did advance some regulations that protected individuals who took out these loans to make sure that they could actually afford to take on these loans and pay them back within a reasonable time. But those rules were gutted in the summer of last year. So again, these protections aren't there. And then when talking about big data and how people are funneled to these products, if you look at the Harvest Moon case, 3 of the 6 named defendants are marketing companies. So if you think about how these products are considered and contemplated, they really are leveraging big data from numerous vehicles. It can be online, it can be from data brokers. They have loyalty programs where if you refer a customer or if you take out multiple loans, you can get gold status. And these loans are profitable by trapping people in what they call the debt trap. Basically, somebody takes out a loan and then can't get out of it because they can't pay it, and the fees just become exponential. And now they owe exponentially more to the payday lender than they originally were borrowing. Up to, I think the standard or the average loan is for like $300, and they'll end up paying, I don't know, like double or even triple of what they originally took out. So if you think about your standard searches online or how you are driven to particular products, if you're someone of low income, and for those of you who don't know how just a small business can leverage Facebook ads, for instance, you can actually be very granular as to what demographics you're seeking. It can be gender, it can be income level, it can be education, it can be a number of levels. You can even seek people who maybe have lost their job recently. During the pandemic, a lot of people were posting personal things about what was going on in their life. And that's a way for the algorithms to scan and look for particular terms that might identify somebody that may want your services. Now, if it's somebody that really is seeking a particular service, that could be seen as very helpful. But when you're in a particular demographic that is only shown certain types of products because you're identified as more likely to purchase those products, it's likely that your feed is going to look very different, and you're only going to be offered products that are potentially more problematic, taking advantage of the fact that you may not have access to the same level of information about how these products are used and what they do. And they further reinforce the poverty cycle. So from that perspective, it's hugely problematic. Add to that in the worst case scenario, for instance, in the Harvest Moon case, where there's highly deceptive and unfair marketing, and they're using practices that are hugely problematic on numerous levels. It only reinforces this process and reinforces mistrust in traditional institutions and traditional access to financial services and products that might be able to lift people out of these circumstances that are potentially temporarily making them strapped for money, et cetera. So data is used in extremely powerful ways that reinforce the structures that keep people siloed into whatever demographics the data is showing that they're a part of. And to get out of that cycle is very difficult unless you're highly sophisticated, which leads to the digital divide problems and access to information and training, et cetera, that can help, make people a little bit more savvy as to how data is being used, where their data is being housed, how it's being shared. And a lot of that is just, it's complicated for what I consider even sophisticated users of online tools. For the general population, it's even harder to navigate, in my opinion. So that's the landscape as I see it. I'm very curious what my co-panelists see the world as in this regard as well.
Yeah, so I wanted to repeat something you said slowly and with emphasis, and see if I can draw our two other panelists in to say sort of what it brings up for them. So I really loved the sentence that you said, where you said that effectively data reinforces its own demographics, so that it perpetuates these tranches that it puts people into. And it's really data and its uses that do that, right? But I was wondering if either of our two co-panelists wanted to talk about examples that they've seen of that same pattern.
I haven't seen examples, but I will point out that online information is a lifeline for people living outside. They don't have access to other information sources in the same way that housed or more resourced people do. So the effects of what we heard Dalia talking about, I think, are acute in the unhoused population. And I'm sure that that leads to seeking high interest money loans and other harms that will entrench homelessness and poverty. So there's a real harm not only to that individual, but as we think about homelessness as a crisis for communities and quality of life in communities, it's something that affects everyone. So it has that collateral consequence that people may not be thinking about if they're thinking narrowly about privacy or algorithms.
I don't have I've been thinking so hard about what you asked earlier, Margot, about the consumer focus. So I'm going to save myself for the question.
All right, we'll come back to that. So since this links really directly into what Dalia is talking about, I'm going to return to that question. So the dominant paradigm other than the Fourth Amendment in the US of privacy protection, and yes, I know there are privacy torts, and yes, I know there are eavesdropping laws, is consumer protection. For example, the Federal Trade Commission's Section 5 practices against unfair and deceptive practices, and the equivalent behavior on the part of states' attorney generals under state UDAP laws, unfair and deceptive practice laws. And so I wanted to talk about that paradigm, right? The paradigm of privacy as consumer protection in particular. There's been a lot of focus writ large on the weaknesses of a notice and choice regime, which is largely how that's been executed in the US, though not entirely. And there's been a lot of focus on, maybe not as much focus on the limits of using consumer protection as a privacy protective paradigm when you start turning to spatial surveillance, right? So Meg Jones famously says, it's the problem of the Internet of other people's things, where you're not really so focused on this direct relationship of consumer to company, but of surveillance writ large, right? Whether it's by third-party data brokers or by a company of somebody with whom they don't have a consumer relationship. So I want to ask the pros and cons, not just the cons. And I heard from Dalia a little bit that UDAP can get at a lot of these things, right? Consumer protection law can get at a lot of what we find problematic. And so maybe, Dalia, if you could talk a little bit more about what does work, and then we can turn to the bigger problem of these theoretical limitations of framing privacy this way.
So I think using consumer protection as a way to deal with privacy issues works to an extent, particularly where there's direct relationships between a consumer and a particular company, or there's actual knowledge of the type of data collection and surveillance that happens. So I know that I have an account with Facebook. I know what I post on Facebook, and I can identify potentially where my information may be misused, or I can identify if my preferences weren't, taken into account or held to. I can also see, I get notifications for data breaches and things like that. And I think that consumer protection law has done a lot to try to get to that. There's challenges of economies of scale for consumer protection law to truly cover individuals and their privacy concerns, because it really takes a strong need for enforcement action. It has to be pretty egregious for an enforcement action to happen, just because of the scale, and because these days a data breach is going to happen. It's not about if, it's about when it happens and how you address it, and are you protecting data, and are you complying with what you say you do from a privacy and data collection perspective. It also it does provide a vehicle for complaints and things like that, which I think is good, because it's a great way to analyze trends and see where people's perceptions and feelings about privacy are. But even in the case of the payday lender, this was not a privacy case, right? This was a deceptive marketing practices and deceptive business practices case. So it goes to show there really isn't a privacy law that would give a right of action or a right of enforcement. It is truly reliant on deceptive and unfair practices, which requires a different analysis and a focus on different elements than specifically the use of data, collection of data, et cetera, which is where states have kind of flooded in with some of the cybersecurity breach laws that are across the country at this point. So while it is helpful and it definitely provides some structure to enforcement and advancing privacy rights, it's not a perfect fit, in my opinion, because the laws don't really address that head on, except for in particular sectors.
Yeah, I want to turn to Karen, who's had a chance to think about this. One thing that I thought of with your Harvest Moon case example is how much there's been an emphasis recently on dark patterns and manipulations, versus really the concerns here, the autonomy concerns here are more about a misprovision of a basic service, right? Like it's not that, I mean, the manipulation is key, right? But the manipulation is not the real harm. The real harm is that you're stuck paying these absolutely exorbitant costs for something that you shouldn't be experiencing, discriminatory practices on you in order to try to obtain it. So it's almost like the manipulation is like the icing on the cake for the thing that, like, the harm we're trying to actually get at. Karen.
Yeah, I'm so glad you brought this up, Margot, because I mean, to be complete, I know you said call it the pros and cons, but to be totally honest with you, I can't overemphasize what a hurdle I believe the kind of historical consumer focus of privacy law and scholarship has been. I mean, I think it was maybe Ann Bartow originally who made this observation about the dead body problem in privacy, right? That there are no dead bodies in privacy, meaning that, again, like you mentioned, right, that the harms are kind of abstract and a little bit maybe dignitary, and nobody really dies, and that this is a problem because it becomes hard to cognize these harms legally. And I mean, it strikes me as bizarre, right? There's only a dead body problem if you are not looking for the dead bodies, right? There are plenty of dead bodies. These aren't abstract harms. They're not abstract problems. The dead bodies are very specific people's dead bodies. They're not dead consumers' bodies, right? That is not, in my mind, the framework that helps us to recognize these really severe, literally life and death harms that accrue from privacy invasion. And I think, honestly, we as privacy scholars have to call ourselves out on this a little bit. I think we, and I include myself in this bucket, overly intellectualize privacy in the same way that folks in kind of technology ethics have recently been sort of reckoning with having maybe overly intellectualized fairness, right, as the concern. I think it's a very similar dynamic, and it's folks like Scott and Simone Brown and Alvaro Bedoya and Anna Lauren Hoffman and Michelle Gilman and all these other folks, right, who are providing this incredibly important counterweight to this tendency by reminding us that, like, no, these are not hypos, these are actual humans. Like, we don't have to work to find the privacy harms like we sometimes do in consumer protection. Like, they're just right there. We just have to acknowledge them and recognize that maybe it's not like my privacy, me, Karen's privacy, that needs to be at the center of the conversation. So that's like one rant. And then the only other thing I'll add that I think is another maybe kind of more logistical limitation of the consumer focus is the kind of conflation of the user with the purchaser, right? Which is something that you kind of hinted at, right? Like, there's much, much, much less attention to, you know, what some people call, I think Alex Lipton calls them secondary users, right? Like the guests in your smart home, right? Or the employee that is being subjected to privacy invasion because of something that a different person purchased, right? Or like a family member purchased, right? So it undersells the importance of the person-to-person privacy invasion that can result. This is something Luke Stark has written a lot about. He and I have written a bit about this together, which is that consumers are themselves often surveillors. Like, consumers can also be the privacy invaders of other people, right? It's not strictly, this is not strictly a consumer dynamic, right? And to sell it as such, I think, like, just turns a blind eye to a huge swath of problems that we should be paying more attention to.
So I have a follow-up that will get me to my last question before I open it up to first to our student questioner and then to the general audience. So my follow-up, I love this, we don't have to look for the dead bodies observation, right? And in fact, Scott in his introduction today said that privacy violations for marginalized communities are often a matter of life and death, not just dignity and autonomy. The harms are not intangible, right? And so I wanted to talk in this particular context, again, when we're talking about poverty or we're talking about homelessness, how this observation that the harms are so tangible should actually influence how we think about privacy policymaking in this context.
Is that back to me, or is this just for the, or Tristia? I think
panel.
Okay, go. Someone else should talk. I talked a lot.
Well, I have an immediate response, and I've made this point before, but I want to underscore it. There are consequences for entire communities related to how we approach privacy rights of unhoused people. For example, unhoused people are disproportionately people coming from carceral settings. They are people who are targeted under laws now that treat their life-sustaining activities as crimes. That creates a huge level of mistrust between those individuals and government. So even when governments are investing in, and sometimes investing millions of dollars and sincere efforts in trying to house people and to serve them in ways that they need, people will not participate in those programs because of the invasion of privacy that they anticipate. And that is, you know, that's a serious issue. And again, not just for the person who is likelier to die earlier because they're living out on the streets. You know, it also means that they're likelier to use our emergency systems, more likely to be hospitalized. There's no clearer point in time in my life that we don't understand how that affects the community at large. It means that people may not be electing to take the service and housing options available to them because they are making a rational choice for themselves based on the history of treatment that they've experienced in the mistrust and what that privacy invasion means for them. And again, that entrenches homelessness and that keeps people living outside where no human being should be living for a lot of different reasons. So, you know, the consequences flowing from how we treat privacy and how narrowly we think about privacy are expansive. And you can find a lot of dead bodies, including literal dead bodies, in our backyards, in part because of how we conceive of privacy.
I also think, just to add, the consumer focus divorces some of the real world harms. And I hesitate to say this because it brings up a hot button policy issue, but it's hard for me to think of privacy, real life implications, real safety of human beings, and not talk about Section 230 of the Communications Decency Act. There's extraordinary First Amendment rationale behind that piece of legislation, but it also contributes to true real world harms that emanate online and end up at people's doorsteps, particularly marginalized people or people who are more likely to be threatened because of what they say, how they say it, you know, where their information is being funneled or what have you. And when we focus solely on consumer protection or the interaction between individuals and businesses, it kind of pulls away from the real world implications of use of data, surveillance, et cetera. In addition, the huge range and arc of how people trust all the objects of surveillance that we use. For instance, I think to Karen's point, if you're the purchaser, if you're the owner of the surveying right now, a lot of people are buying Ring and other surveillance technologies to protect their homes. It's very rational, very reasonable. But if you're on the outside in and it's used for purposes that are highly problematic, harassing, and can really derail your life, you know, where are the lines? And unfortunately, the consent regimes and the focus on consumer protection, et cetera, doesn't address those types of interactions with data collection, both at the personal level and at the large scale level, you know, where a company is collecting vast amounts of data on people. So I wish policy was more informed by the interplay of how data is used and the ethics of that use case and the rules governing that, rather than opting in and out, which creates agency for people who are capable to exercise that, but does not allow for people who don't have the similar access to exercise that agency. And it's a really nitty issue. I mean, I've been very incrementally trying to crack this nut in just my own head, and I don't know that I have any answers. So, anyway, those are my thoughts.
Thank you. So I wanted to have my last question reflect again, again, something that Dalia just mentioned and has come up throughout today, which is this fiction of choice, right? And how the fiction of choice is particularly fictional, as we've heard, about when you're considering a marginalized and low power based population. So one thing that came up for me with the first panel today, in both Francesco Chilla's discussion of broadband infrastructure and Dr. Bridges' discussion of prenatal care provided by the state, was the really like central way in which what we're discussing as privacy issues are really reflective of a potential arguable failure of the state to provide what in most countries would be considered to be basic positive rights. And so I wanted to turn to this as my last question, right? To what extent are these issues that we're characterizing as being about privacy, about surveillance, about policing, really stemming from a failure in the US to solve infrastructural problems, right? And by infrastructure, I don't just mean, you know, wireless connectivity. By infrastructure, I mean all the structures that basically put us at different starting points if you begin with Rawls's veil of ignorance.
I'll just say quickly that I mean, I think that's quite insightful, and I definitely agree with that proposition, Margot. I think, you know, actually Virginia Eubanks makes this argument, I think, really effectively in her book, Automating Inequality, which I imagine many folks have read, in arguing that, you know, a lot of, when it comes to poverty policy, right, a lot of data collection is premised on this idea that we have to know, like, who deserves resources, right? Who deserves a home, who deserves to eat, who deserves for their kids to have medical care. And like, if we start from that premise that like we have to condition these things on good behavior, whatever that means, when we know that good behavior is itself really a normatively laden concept, then we have to like collect all this data to decide who really deserves it and who's defrauding, right? Or who is like pulling one over on us if they try to get access to resources. And that's like that's a choice, right? For that to be the starting point. That doesn't have to be the choice. Not every society uses that as kind of the foundation of deciding who deserves to live, but it does kind of, you know, invite the data collection and the analysis and the prediction that we seem to find so appealing, right, in society. And if we just didn't do that, right? If we created the infrastructure that you allude to so that, I mean, this is obviously a little blue sky, right? But if suddenly people didn't have to compete to eat and to have medical care and to have a roof over their heads, then we wouldn't, quote, need to collect all of this data and create instead this alternative infrastructure of like collecting data to determine desert. Desert meaning, you know, deservingness.
Karen raises an excellent point. I think that's absolutely right. And you know, I'm not a privacy scholar. I'm a legal advocate for unhoused people. So I'm sure there's a lot of context and nuance that I'm missing here. Um, for people in my field, we often think about housing and like a right to housing being the ultimate goal. And one of the takeaways for me as a listener today is that that doesn't solve the privacy problem that we're talking about. People can access what we see as the endpoint and still suffer from the harms that people in housing suffer from. So, you know, I think thinking a theme for me is we have to think really expansively about how these policies, lack of policies, and these bad practices affect not just what their immediate effects are, but what the collateral effects are, and how that influences our way of life in ways that would never be immediately apparent.
All right, so now I get the chance to turn to our first questioner. We have a tradition, as all have seen today at Silicon Flatirons, of beginning with a student. And so, Michael, if you would like to ask your question of our panelists, thank you so much for volunteering to be first.
Yeah, thank you. And thanks to all the panelists. This discussion, so I had some questions prepared and this discussion really blew my mind, sort of. So I'm going to try and formulate this in the context of what you all talked about, which was really, really fascinating. But I have to slightly, I guess, disagree kind of with something that Professor Levy was talking about how the harms are kind of very immediately apparent. I do think that for the majority of people in this space that the benefits of like collection of data that we're talking about are more sort of immediately apparent than the harms. So with the examples that we went through, for example, like with the payday loans, right? To me, the solution to that is like increased intervention from like the FTC, and you're talking about consumer financial protection and things like that. And it's mind-bending for me to think about it in terms of like a privacy context, you know, that like this ought to be seen as like a privacy violation, the fact that you have like targeted ads just sort of in general, which I think most people just sort of like accept as a fact of life nowadays. And also there was talking about in the context of low-income housing, like in order for people to access housing, there's a lot of data collection that occurs before they can access that. And I'm sort of somebody who kind of believes in the power of like big data collection to sometimes paint a picture where you can use that to inform like what is happening on the ground and use that to actually like empower policymakers to make better policy and to just give them more information about like what is happening. And so I was just sort of wondering if you all could just kind of react to that, sort of just what my general perception of it is. Like, do you see that there are actually benefits to these data collection regimes, and that it is actually hard to kind of make the harms concrete for the majority of people in the way that they interact with these things? Does that make sense?
I mean, I can start with some of the benefits, particularly, you know, with respect to government and creating efficiencies, delivering better services to citizens. There is a lot of valuable use of data to help make cities and states smarter, deliver services better, streamline access to services. And data collection relates to all of that. The key is, do the individuals who are receiving the services trust that the data is being used for the positive uses? And I'm a big proponent. I tend to be a technological positivist. I also tend to, believe in the use of data to inform and better systems, et cetera. I think information is key to that. But if you don't have that fundamental layer of trust, it creates all kinds of havoc, to some of Tristia's points, right? So if people won't obtain the services that are very informed by all this data that they're delivering, right? The social contract is broken, and this social contract cannot be healed if the data practices don't follow some line of ethics or norms that everyone can agree to is the appropriate use of data. And part of that challenge is people have very differing opinions about this based on how they're surveyed, what they use information for, what they give information about themselves about. It's not uniform on any level. This is the biggest challenge in this space from my perspective. So how do you advance those positive uses? And how do you engender the trust that many people have when giving over their information, whether it's, surveillance data because we're engaging with the Internet of Things, or we trust law enforcement, so we want them to grant them certain access to spaces in our lives, or we're comfortable giving all of our information to the government because the government is doing the right thing by us, right? And as a civil servant, as someone who shifted into government, that is my goal, right? That's what I want. I hope people will trust me and trust that I have the best of intentions. But the reality is there's a huge portion of the population that does not believe that, because information has been used against them, or they believe information has been used against them, potentially in other contexts, because we don't have this uniformity. And then you get to documentaries like The Social Dilemma that came out on Netflix, that indicates the predictive nature of data. And that's where we really get to the brass tacks of, is data being leveraged properly? Are we starting to take away agency from people? Where are those lines? And I can tell you, I'm not even technologically savvy enough to even navigate this or understand it. So how can we come to the right lines that we shouldn't cross if we can't even come to a common understanding of these things? So I know that's not a great answer to your question because it doesn't provide any solutions, but at least I hope it highlights the complexity and the challenges and the potential to use data in very harmful ways, which can really hamper the very positive ways that data can be leveraged.
I'd like to follow up because I agree with that. And I want to highlight a few ways that mistrust exists, and highlight what the criminalization of homelessness does. So in order to access some of the programs, you are going to be asked questions that will cause you to admit to a crime. For example, if you're a person who lives in a vehicle in a community that criminalizes vehicle habitation, you will be essentially admitting to something that could cause you to be penalized and potentially lose your home. There also are other types of consequences to parental rights, for example. If someone asks you about your family composition and you try to enter into a homeless shelter, homelessness can be a basis for terminating parental rights because it can be considered the only necessary factor for neglect. So there's a real risk. Similarly, people who are undocumented will have legitimate trust issues in giving their private information because there are going to be collateral consequences from sharing that information if they do not trust that that information is going to be used only to serve them. Having said that, are there efficiencies that are generated from big data collection? Certainly there can be. I mean, that is the premise of the coordinated entry system that homeless services are built around now. We also know that, the way that funding, federal funding to communities for homeless services really depends on these data points. You want to show we've served X number of people. You want to make sure that you're covering different demographics, show a reduction in the number of people who are living outside because they've been served by various programs. To the extent that we structure our funding that way, data collection serves a really important purpose. You don't get those federal dollars unless you can provide that data. But from the perspective of the individual, there is risk in providing data.
Thank you. So we're very close to time. I wanted to add an observation and then basically ask two questions from our Q&A and allow the panelists to close by answering either of them. So the observation is that, this really, particularly your answer, Tristia, reminds me of Anna Lauren Hoffman's discussion on the previous panel about the burdens of inclusivity, right? The allocation of the burdens of trying to address disparate impacts and these collateral consequences, which are really serious consequences, suggest in this case those burdens are not hypothetical, right? Those burdens are very real in asking individuals to self-identify in certain categories or having committed certain acts. Okay, so the two questions I have from the Q&A, I'll summarize them each in a sentence. The first is, what is home-centric privacy? And should our understanding of what constitutes the home evolve or change over time? The second, which is very doctrinal, but I think really important for a conference that focuses on privacy and its impacts on marginalized communities, says, can the 14th Amendment play a role here, particularly when you're talking about the Denver-based sweeps on homeless communities across the city?
Can I respond really quickly just to the first point, just to call out some work I really like? So a book that I have found really influential in my thinking, I actually have right here, is At Home in the Law, which is Jeannie Zook's book. And she raises this point that the sanctity of the home that you alluded to earlier, Margot, is like quite double-edged, because in one respect, we want to preserve the sanctity of the boundary of the home, especially for Fourth Amendment purposes. But respecting the privacy of the home is also like a fantastic excuse to just not protect women from anything, right? Or to give them decisional autonomy, right? It's easy to just say, oh, well, that's like a thing that happens within a family government, and therefore just to like wash our hands of it. So I think it's really important. I just wanted to get in there real quickly that we have to think about whose privacy it is that we are protecting when we say that the home matters.
And I'll address the second question about the 14th Amendment. So for those who aren't familiar, the Denver case argues that people who are living outside have a possessory interest in their property protected by the Fourth Amendment. And in order to infringe upon that right, there needs to be some amount of due process, which at minimum means notice before the property can be seized, and some ability to protest the deprivation of the property. So either there needs to be a storage system, or at least that's typically how courts have treated it, or some ability to prevent the permanent loss of property that you still have a possessory right to. So it's separate from Fourth Amendment jurisprudence on privacy, but it's related. So with respect to 14th Amendment law in the homelessness context, I'd point out the value of advance notice. Notice is really critical. We don't accept the premise that people can be evicted from their indoor homes without some advance notice of that eviction. And that premise should be extended. And as we think about what a home means, it should be extended to outdoor homes for reasons related to privacy and kind of corresponding needs, dignity, stability, those things that can be better preserved when someone has advance notice that their property, the place that they call a home, will no longer be available to them. That helps people preserve their property, preserve their ability to find an alternative location where they can be. And those things are really critical. So I think in an indirect way, the 14th Amendment plays a critical role.
And Dalia, I didn't know if you want to take the remaining minute to wrap up with either of those two questions.
I feel like my co-panelists are probably better situated to respond to those questions. But when we traditionally think about what I see as what we're defining as home-centric privacy is that the Fourth Amendment truly protects against intrusions in the home. If you look at just even basic Wikipedia and the Fourth Amendment, you have a right to privacy in your own home. So if you don't have the four walls of your home, then you don't have that privacy. You do not have privacy when you're walking down the street. With respect to your trash, you do not have privacy to the contents of your trash if you put it out on the curb. But if it's leaning against your house, you do. So if you think about somebody who is carrying their effects with them and they're living on the streets in some capacity or a tent or something, they're not granted the same protections from a search and seizure perspective that most people would be if they were within a home. And keep in mind, if you're an overnight guest, you do have that expectation of privacy in the home of the person with you're staying. So I think when we're talking about this, and please correct me if I'm wrong, Trista, because I don't want to mischaracterize this because it's an important issue. I think for somebody who's homeless and has all of their effects and property in a bag, potentially a trash bag, which is why I mentioned the trash component and the case law that stems from that, it would be very easy and lawful for law enforcement to just seize it because it's on public property, it's out in the open. And if, you know, for instance, the person who owns that property walked away for a second, they have no rights over it according to the law as I understand it, but I don't have a depth of knowledge here, so that's about as much as I'll say.
I'm so glad you raised that. Just to follow up on that. So you're absolutely right that even in the personal effects, so, you know, we've been, as I imagine it, we've been kind of talking about that space that people might consider their home, you know, inside their temporary structure. But there's also the space of the community, maybe the encampment, it may be a few people, it may be a lot of people, and the personal effects that people have can be treated as trash in a few different ways. The way it's stored, because maybe trash bags or plastic bags are what's available for storage to people, and that would be seen perhaps objectively as trash, even if it contains really valuable critical documents that people don't want to depart with and have no subjective intention of abandoning. People who have to leave their property, so it's unattended, either for a moment to go to the bathroom, to go to a food service, to go access a shower, to attend an appointment, to go to a court hearing, that property, even if it's stored in a way to suggest that this is unattended, unabandoned, this is unattended but not abandoned property, might still be disposed of as trash. And it can be difficult, you know, in areas outside of the Ninth Circuit. There's a great case in the Ninth Circuit that covers this, but there isn't such case law in the 10th Circuit or in other circuits that would talk about the right to ongoing possession of that property because it can be treated as trash. And another related issue, because unhoused people don't receive trash services in the same way that housed people do, there often will be a commingling, if you look at the perspective of the encampment, of trash and valuable property. So, you know, often people will, you know, try to pile their trash in kind of an area in the encampment that would be the place to dispose of trash, but it may be treated as a large trash site, the tents, all of the possessions in it, because there is also the presence of actual refuse there. So, you know, there are, you raise a great point, Dalia.
So thank you so much to the panelists. I'm going to conclude with just a short statement, and then I get to introduce our final speaker of the day. And my conclusion is basically that you know, there's so many things that I've learned over the course of today, and particularly from this panel. But those most recent points discussing, you know, what is the home, what is trash, emphasizes for me that when we talk in abstractions in the privacy scholarly community, such as, you know, discussion of contextual integrity, it could not be more important to have use cases in which we actually ask whose context are we talking about. So many thanks to my panelists today. And join me clapping from the privacy of your homes and the privacy of your homes wherever they may be or whatever kinds of homes they may be. And now